A very good evening to everyone. Thanks for joining us for the May 2021 labor law update. Um, we start this month uh, with a notification that has been issued on the Code on Social Security 2020. In terms of this notification, which is dated 30th of April, and it comes into force from 3rd of May 2021, Section 142 of the Code on Social Security has been notified. What is the impact of this notification? This notification pertains to unorganized workers and registration of unorganized workers using the Aadhaar portal and the numbers, and only by registering themselves with the consent portal as notified, they'll be able to get the benefits of the government. Who's an unorganized worker has also been defined under the Code on Social Security, and primarily it seeks to register even a small shopkeeper or a tea vendor, or with somebody with less than 10 workers, so a very small petty shop around your corner. All these people are sought to be covered as unorganized workers, and it is for this purpose that Section 142 has been notified from 3rd of May uh, 2021. The next is the central government has circulated uh, negotiating union rules as well on 4th of May, and I asked for the observations from everyone, I mean the employers and employees on this regard. Um, what is quite interesting in this is that the criteria for recognizing a single trade union. We were all under the impression that if there is 51% or more, then you need to recognize. But the rules say that even if there is a trade union which has 30% or more, and if that is the only sole negotiating union in the factory or establishment, industrial establishment, then that trade union would need to be recognized as the sole negotiating union. So it is not 51%. In fact, section also provides in clause 2 that it is this percentage can be fixed by the government. It is following that the government has fixed it at 30%. And the rules also provide that the verification is not going to be done by any kind of a government authority or a mechanism fixed under the government regulations, but the employer himself is to appoint a person as a verification officer, and the verification officer would be doing this activity to find out how many persons are members in which union and what is the membership strength of each union. This process needs to be done once in 3 years, and it can be up to 5 years if it is agreed by the employees. Then this can be done only once in 5 years is also sufficient. You don't need to be doing it once in 3 years. The Karnataka government has published again a draft rules on the industrial relations code. Again, it goes into your certified standing order, section 9A, appointment of judges to the industrial tribunal, whatever was there earlier under the ID Act, similar provisions under the IR code as well, followed by the draft rules, which has already been circulated by the central government in this regard. Nothing significant in that. Uh, the EDLI, on a notification of 28th April, uh, the government has brought in some changes to the EDLI scheme, primarily increasing the EDLI amount. But there was also one provision which said that a person should be work continuously in 12 months in the same establishment for purposes of computing what is the benefit. Otherwise, the benefit amount comes down slightly. Now they removed it, saying that it's sufficient if you work for 12 months in an establishment. It is not that you need to have worked in the same establishment. It is just that you need to have contributed for 12 months. The benefit amount, because of the changes, goes up from 6 lakhs to 7 lakhs. Up to 7 lakhs it could come. And the minimum assurance comes to rupees 2.5 lakhs. And the good part about it is it's a retrospective amendment from 15 to 2020. So any death after 15 to 2020, they would be entitled to the benefit of a minimum of 2.5 lakhs. Similarly, the exemption under EADLI, where you can maintain your own private scheme, now even the additional Provident Fund Commissioner would be able to uh, give you the exemption. It doesn't need to go before the Central Provident Fund Commissioner. The EDLI scheme requires you to file a return, and if you fail to file a return, then the fine amount was 4,000. It has now been enhanced to 25,000 under the scheme. These are the amendments that have been brought about by the notification. Um, Under the ESA Act, the ESA contribution for April 2021 can now be filed up to 15th of June instead of 15th of May. This has been done in pursuant to the Regulation 31 enables ESA Corporation to extend the time frame. Exercising the same, the ESA Corporation has done this. Another one is pertains to Northeast, where certain provisions have been extended to certain areas which were not earlier covered. So the Telangana government has this integrated portal for labor laws where you need to file returns, and this has now been extended by 2 months. So given the lockdown conditions, up to 30/6/2021, the time limit has been extended for filing of returns. The Himachal Pradesh government has given an exemption for a period of 3 months uh, from weekly hours, daily hours, intervals, and spread over. So, and they've also given what should be the norms. So basically, an adult worker should not be asked to work more than 12 hours or 72 hours in a week. And after every 6 hours, there should be a rest of at least half an hour. And the wages in respect of increased working hours uh, shall be proportioned to the minimum wages. But the last part is the interesting part. It doesn't make sense. After granting, if I just go back, they're given an exemption under weekly hours, they're given exemption for daily hours, and the intervals of rest and spread over, everything is being exempt. They say that Section 59 overtime wages will continue to be applicable. We are not sure as to what they mean by this when they're given an exemption on the number of hours they can work. So does it mean that you can work till 12 hours, but you'll be entitled to overtime wages still, is a question that we may need to see, but it appears to be that's the logic behind the regulation. From this week, we just thought we will introduce a new segment in our monthly meeting. So we have got a quiz question that's going to come up. It's for you to see, and you could type in the answer in the chat box, and the last slide of this presentation will have the correct answer as well. Under the Code on Social Security, on completion of building and construction work, the cess has to be paid on a self-assessment basis. Within how many days are you required to do it is the question. Please do type in your answers in the chat box. We shall reveal the correct answer in the end of the PowerPoint. This is an interesting news article that we found, but we are not able to trace the case law, and because it's only the labor code that's passed the order. A certain group of employees have been working, as you are aware, under the ID Act. For the benefits to accrue to a worker, they should have worked for 240 days in a year. The claim of the workers is that in order to defeat that, they have all been engaged as temporary for years together, and they were never engaged for more than 7 months in a year. Therefore, it was always less than 240 days. And in that basis, they had filed a claim petition, and it is understood that the Labor Court has directed compensation of 39 lakhs to 31 persons, and some cases are still pending. And it's quite interesting to see how the Labor Court has granted this compensation. Especially given that they have not worked for 240 days. It is not clear as to on what basis the Labor Court has granted the compensation. We may need to wait for the judgment, but it's an interesting news piece that we found. We thought we should share with you. The Ministry of Corporate Affairs has opened up a portal. So whenever you register a new company, the same company portal of the Ministry of Corporate Affairs gives you a single shot or a single window to get your PAN, TAN, and all the ESI, all kinds of registrations. In the next stage of it, they are now taking it even to the state governments, and as part of it, the Delhi government has integrated their website for registration under the Delhi Shops and Commercial Establishments Act. Uh, so this is something interesting that we will see as a single window coming about. When you do the company registration itself, you will also be doing all other registrations. This is that one more new segment that we propose to have every month hereafter, called the Knowledge Corner, where we want to bring about a certain topic we will be taking up for discussion. And this month, we thought, because of two reasons. One, uh, we thought of taking up the sexual harassment at workplace on two reasons. One is a judgment that has been given by a Goa court on virtual. I'm on a news journalist, where the journalist was acquitted, saying that there was no harassment of his junior. In fact, an organization exposing the cause of women has raised certain questions, including as to whether in the virtual, what happens in the virtual. So we thought on that aspect as well, it may be relevant given the lockdowns, the lot of virtual meetings going on. And the third aspect is, of course, where some schools have also started on harassment complaints against school teachers have also started to come. So all these three things we thought we will uh, take you through in this knowledge corner about how POSH could be relevant even in a virtual period in these COVID times. So if you look at it, it is not because of work from home that the complaints have not reduced. It is still there. The term workplace is no more a physical place. Virtual place is also said to be uh, a workplace. So you're virtual. In fact, there is a judgment of the Rajasthan High Court on the aspect of where WhatsApp messages have been construed to, and that has also been taken as workplace related harassment. Um, what happens on the sanctity of timelines? You can conduct your POSH inquiries online through virtual modes. Therefore, the timelines would still need to be kept up. It's not that you have any exemption with regard to the timelines. And the definition of sexual harassment has not undergone any change, but because of the virtual mode of meetings, it in fact gets extended to the extent, not that the definition gets extended, but it is now going to encompass even all your virtual meetings. Um, More we thought this aspect is where people don't realize many things that could happen. It is more out of non-realization that people could do. So you could have some background if you're going to a virtual meeting where you have your video on and there's something else in the background, which could be taken. This some that could be taken as a sexual connotation. While in meetings, somewhere you could inadvertently try to show some objectionable material, and of course it could be intentional as well. So all these things that happen even during a video call could amount to a sexual harassment. What kinds of things otherwise are happening is about clothing, how you clothe yourself, uh, and asking people to switch on their video, not giving them the comfort of, when they want they can switch on the video. These are also issues that could come up in your virtual meetings. So what you may need to look at is a SOP on virtual meetings, how training your employees, even as to the fact, first of all, bringing into their notice that even virtual meetings would constitute harassment. Anything done in a virtual meeting could also constitute harassment. And then you need to sensitize your employees on this regard. So we thought that would be our first knowledge corner for this first session on knowledge, first segment on knowledge corner. We will try to cover that. So this is what we thought we should know. Continuing with our presentation on your know your codes, um, all establishments employing 50 or more employees, it's not women, it's employees, is required to maintain a creche under the code on social security. Only good thing is that you could pool your resources and have a common one. It is not that every establishment should have one independently. So if you're in a common workspace in a building where many companies are there, many offices are situated, you could all pool in together to have one common crash facility. Uh, the ESA enrollment numbers went up and down, and we need to see what's going to happen in May. But there has been an improvement in March, uh, so we shows that the number of people getting employed, the employment rates going up is a good sign. What kind of different benefits that companies have come forward to release during the COVID times? So, for instance, one company has said in the event of death, they will continue to pay the employees their full salary to the family till the date of retirement. Many companies of different kinds of insurance benefits have been extended. So these are things that you may need to ponder as HR fraternity on what better benefits you're going to extend to your employees. One of the ECART major has decided to hire around 23,000 employees. This shows that our economy is coming back to normal, or at least the e-commerce economy is growing very fast. And with this lockdown and the more and more government restrictions on physical opening of things, but providing for e-commerce, the e-commerce marketplace is trying to become a big boom. Um, Again, one company has taken up a decision that it will be the first concept of work from anywhere. We all heard of work from home, but this is on work from anywhere. So you can be anywhere in India and you could connect and work. You could walk into any of their offices and work. So that is the kind of thought process that company has brought in. Um, we just thought about one on BOCW Act. This is a question that came to the Supreme Court was the contractor had around 5 contracts with the electricity board, including supply of material, but also where he had contracts to uh, install the material that he's going to supply or install the transformers, etc. But there were 5 different contracts, and the demand was made on BOCW cess on the entire 5 contracts. The Supreme Court has held, even though they are all linked or contracts, there are still 5 separate contracts. And if there is one contract only for supply of material, you don't need to pay cess on that. So on materials that are supplied, a cess need not be paid. So therefore, going forward, instead of having a composite contract of which has materials in it, you could consider taking out and having only a contract for materials, and that in that manner your cess amount comes down, and you could rely on this judgment of the Supreme Court in this regard. Another, as you rightly, as we started, we spoke about Section 142 being under the Code on Social Security. Where does it flow from? The Supreme Court has asked the central and state governments to look into unorganized workers and their benefits. So you're all well aware during the last lockdown this started, and following up with that, uh, they have asked the central government to create a suitable mechanism to monitor and supervise the distribution of welfare schemes, and it's part of that. Section 142 has also been notified now by the government. Again, one more new segment we wanted to bring in is where a company posted online in the digital platform saying that one of its employees spends around 120 minutes per day in the washroom, and it asked in the social media platform what kind of action it needs to take on this employee. Different kinds of responses came about. Uh, but we thought it's a funny one to say that this kind of complaints also arise in workplace. The last is the complaints segment. What are the different complaints to be done in different states during the month of June and July is provided for. And the answer for the quiz which we had posed the question, it is 60 days. So you would need to file your returns within 60 days and pay the cess within 60 days. We thank you for joining us. We look forward to meet you again on 26th June at 4 p.m. Stay safe, and please do join on 26th of June. Thank you.